Good evening, everyone. I'm Samyukta from 𝘨𝘃𝗀, and I'm very glad to host this session on remedies available against the false case or false evidence. Today, we have with us Ms. Sanchita Ain, an advocate on record in the Supreme Court of India. She has over 9 years of experience in the field of law, and she has handled various cases such as the Triple Talaq case and the 2G case. It's an absolute pleasure to have you, ma'am. Over to you, please.
Thank you, Samyukta. Thank you for the lovely introduction. I have a small PPT that I'm going to share now, and you guys can ask questions in between, not a problem at all. And Samyukta, you can interrupt me anytime you want to. I'll have to minimize this. Yeah. Right. So let's start with what the criminal law provides for. We'll be focusing on remedies today and see how we can weigh one remedy against the other and how to utilize them in the best possible manner. As I don't know whether you would have noticed or not, but not many cases get filed for registering a false complaint, etc. People get FIRs quashed, but they don't go after that guy. So let's see what you can do in order to make the system more effective, in order to reduce the number of false cases that are filed. I think once you avail of these remedies more often, that will help in the administration of justice generally as well. So let's see what it is. So let's start with false evidence. What is a false evidence? And the IPC. So first we are focusing on IPC. We're focusing on one sort of remedy that you'll get to know later what that remedy is actually. So what is giving false evidence? It's defined under section 191. We also loosely call it perjury. So there's no provision specifically to say that this is perjury in the Indian law, but largely section 191 is what perjury is. When someone is legally bound to state the truth and the person lies. So now a person can be legally bound for different reasons. A person can be legally bound when the person is stating something on oath. Now that can be, so I'm trying to make it, intelligible for everyone, even for people who are not lawyers. If I'm able to, please feel free to interrupt me. The person may be legally bound by an oath. So suppose a petition is filed and that has certain false averments, right? So in that case, then that person is violating the not just law of oath, but the person is giving false, is stating something false on oath, and therefore that person will be liable under section 191. So it can be in pleadings also, because at the end of the pleadings, this is for non-lawyers, you are signing an affidavit that says that all that is true to the best of my knowledge and beliefs, and that's on oath because it's being notarized by the oath commissioner or notary. So that's one. Then the other is witness affidavits again. That is kind of obvious. What is not obvious is even when it's stated in pleadings, it can be false evidence. And then during cross-examination, again, it's under oath, that's obvious. Any form of affidavit that you file, if it states anything that's false. So we'll come to differentiation between wrong and false. Something that you don't believe to be false and something that you could not have known that it is false. So there are different categories. For now, we're just understanding what false evidence would be. So if you know it to be false and you still say it, like you understand what lying is. So if someone's lying, not it's different from someone not knowing something and therefore saying it, right? So that is what comes under giving false evidence provision. Okay, then it's not just when you're bound by an oath. It can also be when there's an express provision of law that you need to state the truth, or you are bound by a law to make a certain declaration. So I'll give you an example. A forensic expert, right? So a forensic expert is supposed to give a correct report. So if the person refuses, if the person does not do it and files a false report as opposed to incorrect reports, it can be incorrect. It may not be false, but if the person knows that or has reason to believe that what he's filing is not true, he has examined it, he has come to a conclusion, but knowingly he's stating some other conclusion, then of course he is giving false evidence. It again need not be in written form. So it can be if, say, a party is asked by the court in the courtroom what what happened, and the person says makes it up right there. That can be false evidence as well. Even if someone says, "I believe this had happened," and if you cannot, and if you can successfully show that he could not have been under such belief. So it's not just not about knowledge; it's also about belief. So if the person had reason not to believe something, and the person said, "Oh, I believe this is what had happened," then even that comes under giving false evidence. Now, the second aspect would be fabricating false evidence. So one is, of course, is stating false evidence, and another is so it's not like someone just states of false evidence. Sometimes what happens, one person fabricates it, another person states it. So in that case, what is fabricating false evidence? So it's it's again it can be in different forms. It can even be, and some people don't know this. So if someone's implicating you, like if someone's making a circumstance to exist against you. For example, if someone puts a wallet in your bag, right? And the intention is that you get caught and you'll be convicted for theft. So then that's fabricating false evidence as well, right? The next one is if someone makes a false entry in any book or record, the intention has to be that it's to be used in a judicial proceeding against someone. That's also fabricating false evidence. The third category is if someone makes any document containing false statement. It can be partly false, it can be wholly false. Again, it has to be used as evidence in a court. It has to be prepared to be used as evidence in a court. Only then it will constitute fabricating false evidence under this section. Again, the nature of this evidence, planted or fabricated, must be such that it may cause the judge, here we are just concerned with judicial proceedings, to form an opinion that has bearing on the outcome of the case. So suppose the person kept a wallet, but the other person was never charged with theft. He's charged with something else, or some suit is going on, and the person says, "Oh, he kept a wallet in my bag one day once." That's not fabricating false evidence because that's not being used in that case, right? Okay, my voice is slightly breaking. Okay, so I will just try to resolve it. I'm so sorry about it. Let me pause sharing for a while.
That's completely fine.
Huh?
No, that's completely fine.
Okay. Is this any better, Samyukta?
Slightly.
Slightly better. Okay, because there's nothing else that I can do about it. Right. So let me give it a try again. Right. False declaration. Now, false statements can also be made when a person is giving a declaration, which is to be used as an evidence. So, if you're bound by law to make a declaration and you're giving a wrong declaration, like issuing a false certificate, all that, and again, that certificate has to be used in a court of law, then that also comes under this provision. And the remedy for all of these is the same. That's why I'm discussing all of these under one head. So that then when we discuss the remedy, you know that if any of these is being done by a person, what you can do, how you can ensure that the person is punished. Okay, using false evidence, if someone knows that any evidence or declaration is false or fabricated and yet corruptly uses or attempts to use. So even attempts to use is covered. Sometimes the issue has been whether something was produced as evidence or not. So even attempts to use is covered under the section. To use it as a true or genuine evidence or declaration if the person is even using it. So it could be that the person has not made it, but even if the person is corruptly using it, intention matters here. So if you do not know that it's a false evidence, then of course you can't be charged. But if there is a proof that the person knew and yet was using it, then of course the person is chargeable under this provision. False personation. False personation, again, this is not just in criminal proceedings, it can be in any proceedings, and it will be an offense under these sections of IPC. So, false personation would be that if you are falsely personating yourself as in the person and making any admission or statement as that person. So that person can get implicated in a criminal proceedings, or something will happen. So whatever happens, whatever the outcome be, if you're falsely personating a person and making any admission or doing any act during the proceedings, it can be in a suit, it can be in a criminal proceedings, it you will be charged under this provision. So if someone else is doing that, you can definitely bring them to books. I think it's very important to do this, because otherwise people get away and then they do it in some other matter. There are some professionals who go around and do this. So I think it's very important that people take this seriously. And even for witnesses, I mean, if a witness is also falsely impersonating himself or herself as somebody else, then I think you should do something about it. That I'll be talking about what you can do. Okay, is my voice okay? Can you hear me?
Yes, ma'am, we can.
So, fraud relating to property, let's see what these are. So, one is fraudulent removal or concealment of property to prevent its seizure as forfeited or in execution. So suppose an order has been passed by court that certain property has to be seized, and you fraudulently remove it or conceal it. Just a sec, there's a chat. Let me see what it says. I can't see it anymore. Can you help me, Samyukta? Is there something important that's being written there? Uh,
It says not very clear, low audio.
is it okay?
I can hear you. Not sure.
Okay, so what I'll do is I'll try to be louder, maybe that can help, and I'll just bring myself closer to the mic. Yeah. So next is with relation to property. So fraudulently removing or concealing a property. Suppose there's a court order. Okay, it could be just my voice. I think I need to have a something going on here, so I need to work on that also. So so suppose property is fraudulently removed or concealed, because there is a court order that says that the property has to be seized or forfeited, then in order to prevent such seizure or forfeiture, somebody fraudulently removes or conceals the property. Again, the intention is important. If it was with a dishonest intention that the person removes it, the person has to be aware of the court order. And if the person is aware of the court order and he still removes it or conceals it, then of course the intention will be presumed. The next aspect, of course, is fraudulent claim to property to prevent its seizures. So, suppose you buy a property which you know is something that is there is a court order that has stated that it has to be seized, or it's part of a court order whereby you if you buy the property you will be as a if you are bona fide, then it will help somebody in some way, etc. So all those kind of sometimes people do that, just to create third party interest. Somebody comes in the picture and buys it, so even that person can be charged under the section. Fraudulently suffering or obtaining a decree. So sometimes what happens, just to beat the order. So there's a suit going on, say with respect to a property, and somebody just gets into another, just files a fraudulent suit against the person, and the person, uh, fraudulently loses the suit just to get a decree in favor of. So suppose as ABC, A and B, A has filed a case against B. So B will get C to file another case against himself, and then will fraudulently lose the case. So that C gets benefited, and then and it will cause loss to A, and then B and C will share the proceeds. So that's how sometimes people do. So even fraudulently suffering a decree or obtaining a decree, which she is doing in this case, comes under, is punishable. If someone makes a false claim, so first let's understand what a false claim is. Okay, so dishonestly making false claim in court. So if it's done with an intention to injure or annoy, or even if that intention is not clear, someone dishonestly or fraudulently makes a false claim, knowing it to be false. Claim here does not mean just relief. It's not just that you are seeking something that's false. No, that may not be false. Claim could be even a fact on which the relief is based. So, a false statement, false claim, more or less, it's the same. It just depends where and how you are making it, etc. It may be made in a plain petition or application. It can be criminal. It can be civil proceedings. It can also be made in a, so for a false claim, it need not be on oath. It can be made anywhere. But of course, all these petitions, everything that you mostly file before court is on oath. But even if it's on a note, it's still a false claim then if it is honestly made. Uh, it can also be made in a written statement, counter affidavit, or reply while denying any fact. So it's not just about existence of a fact. If you're making a false claim about non-existence of a fact, then even that will attract this provision. So all those plain denials that happens in the WS, I mean, all of those attract this provision if it's being intentionally, if the person knows it to be false and is yet making it, then it will attract section 209. False charge. Let's see what false charge is. False charge, of course, is only pertaining to criminal proceeding. So if somebody falsely charges a person for committing an offense, knowing that there is no just or lawful ground for such proceeding or charge, then that comes. So this is strictly criminal in nature. That's the only difference.
Ma'am, I'm sorry to interrupt you here, but we have a question. Can we get an example on fraudulent suffering?
Right. So, right. So, say there is a property on which A has a rightful claim over B. Say A had entered into, A had given a loan to B, and as a security, B had given a property. Now, C comes in picture and lays claim over the property for on some fraudulent basis, and B intentionally loses that case so that A's claim can be defeated. And then B and C divide. I mean, they are have a dishonest intention, and they kind of divide the share among themselves. So this is not the best example, but something of that sort. I'll give you a live example. So there was this person who was a director of a company. Now the company got into many fraudulent transactions, and finally, they didn't say they were also into building. Uh, Flats, etc. And they took a lot of money. But finally, they didn't hand it over. And what they also did along with that was they put this money in different places. They bought stuff uh, from out of this money that they got from the investors. They bought stuff, they bought other properties, and then some other person laid a claim on it who was actually their man. They intentionally lost that case so that the property could go to that guy to whom it never belonged, so that they didn't have to pay their debtors. I mean, from out of that money, they didn't have to pay, and of course, the company was being wound up, etc. There was an official liquidator, so at least that money he could secure for himself. So it can be that convoluted, but so long as you're fraudulently losing a case, even that is punishable. I hope I made myself clear. You'll have to tell me in the chat box. I won't proceed till you tell me.
Sumati, was that clear? Like you can proceed, ma'am. She'll let us know.
Forgery. Forgery, section 463 of IPC. Making false documents. So forgery, sometimes we use it casually, or even cheating, forgery. These are the words we generally use. Forgery in technical terms would mean making false document, even if it is in part, it still constitutes forgery. It need not always be that you are applying whitener and changing something. It can be just making it fresh. That's also forgery. The intention should be to cause damage or injury to the public or to any specific person. It can also be to support any claim or title. So you want to claim a property, or so you forge a document, a sale deed, etc., or to cause any person to part with property. You want to contest somebody else suit and kind of say that it's mine, and you are forging a document to show it. The intention can also be to enter into any express or implied contract. The intention can also be so it can be the basis of sometimes people enter into contract by showing a certain document, look, this belongs to me, and then it doesn't work out. Obviously they later on find out. So it can be a case. So it's not necessary, it's not a breach of contract, it's actually forgery. The intention can also be to commit fraud, or that fraud may be committed. So forgery can be done in order to commit fraud. So it will attract both the provisions in that case. Uh, Using as genuine a forged document. Using a forged document is also comes under the section that we're discussing right now. Counterfeiting. So again, counterfeiting, if someone's counterfeiting any device, anything that's used to authenticate a document. So suppose you have a false certificate, etc., that people prepare, then even, and that's being used in a judicial proceeding, then even that will come under, that is punishable. How to do it? Now the question is what to file, where to file, when to file. When any of these offenses have been committed during a judicial proceeding. So sometimes, of course, the court will take cognizance by itself based on oral submissions. But if it does not, then you move an application under section 340 read with 195 of CRPC. In the same court, this is very important. It's to be moved in the same court. That's what section 195 provides. It says you cannot move before any court. No other court has jurisdiction over these offenses when it is committed in or in relation to a judicial proceeding. You have to move in the same court. You have to move an application under 340 read with 195. It's more to do with protection given to the parties involved, so that nobody drags them and files frivolous complaints against them. But at the end of the day, this is the procedure, and therefore it's sometimes easier to get an order when you file it in the same court, because say the court has come to a finding that this was this was a fraud played on the court, and then if the court doesn't take action itself, then you can move an application and say, hey, you came to this finding now based on this, please initiate proceedings under 340. So you move an application in the same court, and then it can move at any stage. Now, it's moved, of course, only if it is committed in or in relation to judicial proceedings. You do not file an FIR when it has been committed in relation or in judicial proceedings. Any of these offenses. So even if there are other offenses, sometimes lawyers don't give proper advice to their clients, and the FIRs get quashed, and then you have to go back to that court. So you don't move an FIR when any of these offences have been committed during judicial proceedings, uh, even if other offences have also been committed. So you may think that 420 has also been committed, but still you don't file an FIR if there has been a false claim, there has been fabrication of documents, etc., during the and has been used as evidence, and these ingredients have been fulfilled. I'm coming to that. Then you move an application under 340. The court may, of course, make a preliminary inquiry under 340. That's the purpose of 340. Whether it is bound to make a preliminary inquiry and give opportunity of hearing, and what will be the scope of this inquiry, this has been referred to a larger bench in February 2020. So before that, of course, since there were contradictory views of concurrent benches, uh, the court, of course, will record a finding to that effect. Once the court goes through the application of yours, then the court will record a finding that yes, it was fabricated. Then it will make a complaint thereof in writing. It has to be in writing. This complaint will be sent to the magistrate of first class having jurisdiction, and then the court can also take sufficient security for appearance of the accused before such magistrate. So even before that the magistrate initiates action, this court has the jurisdiction to do all of this. It can take sufficient security for appearance. He can even send the accused to judicial custody of that magistrate if the alleged offense is non-bailable. Even that can be done. He can also bind over any person to appear and give evidence before such magistrate. So all of these have to be in your prayers, otherwise the chances of getting these relief are big. Uh, so, if your application is not acted upon by this court, then of course you can file, but it should not be rejected. If it's rejected, then it's a different case. But if it's not rejected and it's just lying there because the court doesn't want to act on it, and that happens quite often, then you move on to 342 before a court to which this court is subordinate. So suppose High Court is not acting upon it, and I have done that. I've moved before Supreme Court under Section 340, subsection 2 of CRPC. So sometimes this court is reluctant. So the whichever court is higher in authority, which means whichever the appeals go to, that court can act upon it. Other remedies could be defamation action. It could be criminal contempt. So a lot of defamation cases are filed when false complaint, false FIRs are being registered against people because it is loss to reputation, harm to reputation. But the problem is the court won't act upon every such case because if they start acting upon, if A does not succeed against B, then A goes and files a defamation case, or say B goes and files a defamation case, etc. So it doesn't necessarily mean it's a false case. So you really need to establish that it was a false case which was done with an intention to. So all that becomes necessary when you're filing a defamation case. So the ingredients could be different for different cases. So you need to keep that in mind. Again, you can go for criminal contempt. Sometimes courts themselves, instead of initiating an action under 340, they initiate contempt proceedings. So say a doctor comes to court and says that an accused is not fit to surrender, etc., and then it later comes out that it's not true. The accused was just evading summons. Then the doctor can be charged with criminal contempt by the court. So if you can prove that uh, any conduct of a person is prejudicing or interfering, or it tends to interfere with the due course of any judicial proceeding, or it's obstruction of justice, then of course you can move for criminal contempt action as well before the court. So you can, if it's a subordinate court, it will be referred to the High Court, and the High Court then has the power to punish for contempt. If it's before High Court, then of course High Court will itself initiate action, but you can always move an application and request them to initiate action against the person who is obstructing justice or who is interfering with the due course of judicial proceeding. So any of this can fall under a criminal contempt definition as well. So it's your call what you want to do, how you want to do. Of course, there are factors that you need to keep in mind. So your first option should be to initiate 340. But if you think that you want it to be quicker or you don't want to get into criminal proceedings, etc., then criminal contempt is summary proceedings. So you can go for criminal contempt. Depends on what you want. Quick recap. So it is a false claim, false charge, false evidence, false declaration, forgery, counterfeiting, all of that we discussed. In any judicial proceeding or in relation to any judicial proceeding, you move an application under Section 340, read with 195 of CRPC before the same court at any stage. Mostly people do it after the proceedings are concluded, but some people, the moment that fact comes out that it has been wrongly, it has been falsely stated, then some people prefer to move the application right away. FIR complaint before any other court is not maintainable if it is made in or in relation to any judicial proceeding. As I had explained before, that you should not file an FIR if any of these provisions are retracted during judicial proceedings, and even complaint before any other court for these offences in a judicial proceeding are not maintainable. You can go for defamation, you suit for complaint, people prefer a criminal defamation case, then you can also go for criminal contempt proceedings. What to keep in mind? So, what you need to keep in mind is that the materials produced before the court must make out. So do you have any questions so far? I think I can take some questions at this stage before we go any further. Okay, so the materials produced before the court must make out a prima facie case for a complaint for the purpose of inquiry into an offense referred to in this case. So it has to be there has to be a prima facie case being made out, and it has to be expedient in the interest of justice. So the court will see, the court has to be satisfied that this kind of inquiry is required in the interest of justice and is appropriate in the facts of the case. Only then will the court get into 340 inquiry. So you need to prove a prima facie case, and you also need to show why it is in the interest of justice. And then I'll tell you how to show whether it's in the interest of justice. So in the formation of opinion by the court, whether it is expedient in the interest of justice or not, the requirement should only be to have a prima facie satisfaction that the offense has been committed. So the moment you do that, it's enough to show that it's in the interest of justice. But along with that, there is a second requirement that you need to show. Since it's in the course of judicial proceeding, you also need to show that it will cause a very serious or substantial, it will affect the outcome of the case. It was of such a nature as would have affected if the fraudulent if the false claim or evidence would have been relied upon, then the court would have come to a different conclusion. Therefore, this has to be proved that it's not necessary to prove that it has caused you any serious or substantial injury to the person who is moving it. No, that's really not what the court gets into. It may have caused you a serious injury, but that piece of evidence should have had impact in the administration of justice. It may not have had, ultimately it may not have impacted the outcome of the case, but it definitely had the potential to have an impact if the court would not have come to a finding that it was being fraudulently made, then it would have had an impact on the outcome of the case. That needs to be shown with the help of facts. Right. The mere fact that the person has made a contradictory statement in a judicial proceeding is not by itself sufficient to justify a prosecution under 199-200. So it can be contradictory. So it can be contradictory, but suppose a witness says something in his witness affidavit. When he's called to cross-examine, he states something else. That can happen, contradictory. It happens, and that's how we prove that a witness is not credible. Just because a witness is not credible does not mean he can be tried or he can be punished under 199-200. You need to show the intention. You need to show, in order to prove the falsity, you need to show that the person had dishonestly done it, or the person knew it to be false and yet he was making it. Intentionally, it has to be, the intention has to be shown. The prosecution has to prove that the accused made a false claim. When you're proving false claim, you have to show that just a mere proof, the accused failed to prove his claim. That happens often. Uh, just because you have somebody has failed to prove a claim against you doesn't mean that the claim is false, or the complaint, the case is false. Even for false charge, that applies. So one needs to be careful. It can be shown with the help of evidence, with the help of the way you narrate the facts, etc. All that becomes important so that the court believes that that there is a prima facie case made out there, and then only the court initiates further proceedings. There's distinction between claims that may be regarded as legally hopeless and claims that are false. So just because a claim is would not succeed does not mean that it has to be false. So there are clients who come with all sorts of cases that won't stand in the court of law. It will harass the other person, etc. But just because the case is legally hopeless, just because he or she may not get relief, or you know for sure the person won't get a relief, that in itself does not make it false. So you really don't need to prove this, that this person could not have got the relief that he was seeking and therefore prosecute him. No, you need to show that either it was dishonest or it was done with a certain intention to injure or to harm. So you need to ever certain specific facts to tilt the court towards you, and then the proceedings proceed as they proceed. You then produce evidence to show why, how the person would have known, and still he acted upon it, etc., etc. So all that has a bearing on whether proceedings are initiated under 340 or not. Right. So we can
Are
take.
there any questions? You can post your questions in the chat box. Meanwhile, I myself have a couple of questions. Ma'am, when you were explaining false evidence and fabricated evidence, you made it clear that the remedies are pretty much the same.
Right.
Isn't the general intention that is there in false evidence as opposed to the particular intention that is there in fabricated evidence completely different, and shouldn't the punishment be way more severe, is my question.
Right. So punishments are different. When I was talking about remedy, all I meant was that you need to do the same thing, because generally people don't know that it's under 340 that you need to go even for fabricated evidence during a court proceedings. So I was just talking about that part. Of course, the punishments are different. So for say false for false statement, false declaration, it's all the same. But other than that, it's different. So for false personation, it will be different, for example. So yeah, I hope that answers the question. I can tell you the exact punishment for. So again, there are aggravated offenses. So if you are doing fabricating false evidence with intent to get somebody convicted for a capital offense, that's aggravated offense then. So yeah, punishments are bound to be different. For false evidence, it can extend to 3 years. For fabricating false evidence, it's the same. It's 3 years only, because ultimately it's having the same effect on the proceedings.
There is a question by Sumati again. If the acts are done by public officials, then how are they dealt with?
Right. So you mean to say that if so you're saying that if there is a see, it can be the same because you as a private person are moving the court and it has happened during the judicial proceedings and in the course of it, then of course you have to move under 340. There's no other way you can move under any other provision. So though there are provisions where it would attract other provisions if it would have been committed outside the court or beyond the scope of the judicial proceeding. But since it has been committed during the courts in or in relation to the judicial proceedings, then of course it has to be these provisions. You cannot go beyond it, even if it is committed by a public servant. Okay, in civil matters, same code registered forged documents. I didn't get this, Aditya. If you can just clarify this question.
Um, I'm not sure if he's there. Yeah, he's there. Aditya, can you please elaborate on your question?
Okay. Any more questions you would like to ask?
Is there a difference between the concept of perjury in India as opposed to the one in English law? And isn't that more severe? And can you make a difference?
Right, it seems to be more severe because the origin is in the, of course, Black's dictionary defines perjury, and we have got a law from the UK. But the point is, since we hear it so often, perjury, and it's used more often there than we do it in India. In India, it's mostly done by people who are on the wrong side. So that's unfortunate that innocent people don't want to go after and they're not that aggressive. They're like, yeah, we're out of it, done, dusted. Uh, in civil matters also, the same procedure for forged documents. So it's punishable under IPC even if it's being done in civil proceedings. So this is a good question. Yeah. What's perjury punishment in case of 125 CRPC? Wife lie, she is not working. Again, you Samyukta is smiling because she had the same question. But yes, so of course you need to once you are able to show it to the court, you show it to the court, you get a finding from the court, you move application under 340. Court gives a finding. So it works both ways. Sometimes the court gives a finding, passes an order in 125, then you file 340, or you file 340, court gives finding, files a complaint before the magistrate. That's how it goes. So, of course, for 125 CRPC also, you have to follow the same procedure. Of course, Chhattisgarh has some aggravated punishment for some offenses. It's very interesting to see, but unless someone's from Chhattisgarh, I'm not going there. Can we raise the issue in a civil partition suit as well? Yes, you can. Yes, you can. You can definitely show that a document has been fabricated or a certain sort of forgery has taken place, or yeah, so if any of these has happened, somebody has made a false claim. But again, the threshold is a bit higher because nobody wants to jeopardize the interest of a person who has filed a case, even if it's the person finds it difficult to prove it. Otherwise, it will discourage people from filing cases. You know, if they know that a false case will be filed against them if they are not able to prove it. So the ministers will be reluctant or any court will be a little reluctant to initiate 340. But if it's crystal clear, then once you get a finding, it's always better to first get a finding in the order that this is what it is, and then you move 340. But otherwise, in 340, if you start proving it, it's like a parallel proceeding. It will delay these proceedings, or that application will be kept pending until this is decided. So it means the same thing ultimately. First this gets decided, then you move 340. We have showed it through documents, everything is live. Then of course the court will come to a finding. Ultimately, it will be easier for you to to move 340 after that, because now if you do, it's either that will remain pending or this will remain pending. Ultimately, the court will have to come to the same finding. So I think it will be advisable to first wait unless you want to. And sometimes people move 340 just to pressurize, but to pressure, to just kind of show to the other party what we can do against you, etc. And when the matter is finally decided, they are not very keen to pursue 340. So you can move now itself if you want to make a statement. Right. Any other questions? Yeah. If forensic reports are proved to be false, do the doctors get prosecuted? It has to be proved to be false. If it's proved to be false, as in, there's a difference between negligence, there's a difference between mistake, and when somebody is doing it intentionally, dishonestly, fraudulently. If you can show, it can be shown by any evidence. So if you can show that the person has taken money from this guy, so all these come as these help to show that it was done fraudulently. Then you can show that it's false. Otherwise, it's difficult to prove that a forensic expert has given a false report, because they're kind of protected if you cannot show it with express evidence that it's false. Any other question?
Ma'am, there was this recent case that was filed in December, wherein a woman filed a false rape case against a man, and then she issued an unconditional apology to the Delhi High Court, and they forgave her. There was nothing against her. Is that the court?
How
The
can court forgive?
As in, they didn't prosecute her or anything in that matter, and nothing was held against her as as a criminal charge.
Proceedings, it won't be unless you move a 340. So ideally, if the court is not doing it by itself, then you should move a 340.
Right.
Like there's this just case today. Orissa High Court has acquitted a man of attempt to rape charge after 30 years.
Oh.
Yeah, so just because he's been acquitted doesn't mean, see, the problem with these cases also is that it's difficult to prove. So does not mean it was a false case. Just because there are low conviction rates. There are low conviction rates because sometimes the prosecutress herself comes under pressure and does not want to push the case further because of XYZ reason. Like I have withdrawn cases. So as in DV cases, etc. Doesn't mean the woman was not stating the truth or was making false allegation. Sometimes that also happens. But the thing is, whoever has suffered, they should definitely file a 340. Anything else?
Any other questions? I think we can end the session, ma'am.
Right. So all these issues regarding misuse of certain laws, I think this is the answer to all of that, because it's the same for every offense. So whether you're being tried under 498A, whether there's a false case of theft, you have these provisions to protect you. And I think these should be used more often. Of course, they don't protect, but they protect. I mean, they kind of do a great service in the administration of justice in future when you have these kind of judgments saying that the person who made a false claim is being prosecuted. How many times do we hear these? So we need to hear them more often. It's very important, and it's sometimes it's easy to prove falsity, but people just choose to get the FIR quashed and they sit quietly. I think 340 proceedings should be moved more often. Yeah, so before evidence, can we file perjury? Best stage to file perjury. So of course, depends on where the false claim has been made. So if it has been made, of course, when you say before evidence, I think you mean that during the pleadings, in the pleadings itself, there is a false claim that has been made made, or document has been, the document would not be exhibited before the evidence stage. Therefore, if it relates to a document, you need to wait till it's proved by a witness, etc. Then you move 340. But if you're asking for best stage, it's of course after the finding has come. And it can be, it does not mean that matter will get disposed of. Sometimes in one case when I had filed a 340, when they were relying upon a board resolution, while the board resolution had a signature of a board of a director who was abroad, right? And they were basing their claim on that board resolution. So it immediately got proved that she was abroad, and we could move 340 immediately, even before the case was finally decided. So that's possible. Right. Thank you. It was crisp and clear. Thank you so much for saying that. I thought I don't know if I was clear. I was not enough. I'd been working. I slept for 3 hours. So I was like, I don't know. Thank you. Thank you, everyone, for being patient with me today.
Okay, ma'am, I think we can end the session now.
Right. Thank you so much. Thank you. Any other feedback?
Thank you so much for everyone for attending, and thank you, Sanchita. Even I learned a lot. Thank you.